All right, now, Attorney Percy King here talking to you today. We're going to talk about Steve Bannon being indicted for the same acts that he was pardoned in federal court for by President Donald Trump, or former President Trump, and whether or not that's double jeopardy or not. Here's the thing. I actually had a small role in this case because for a short period of time at least, I represented one of his co-defendants, and that was when I was an assistant federal defender. I was representation for what's called a Rule 5 hearing. What happens is that wherever you are arrested, no matter what the indictment is, you have to be taken in front of a United States magistrate judge, and you have what's called an identity hearing to make sure that they arrested the right person, not that you're guilty, but that they actually have the right person, right name, and the right individual. You're also read the charges, and then you have a detention hearing to see if you're going to be detained or not. I can say that I was able to get that person out without any type of bond. There was just conditions, so not even a signature bond, so there was no monetary paper necessary. Now, all the other three, they had different types of bonds. So ove forward, I can tell you that I have seen the documentation about the case, and I do know that at least two of the defendants have pled guilty in federal court, but have not been sentenced yet. It's been moved to December. So I'm going to tell you, as a person who practices in federal court criminally, one of the things that we always worried about is something that's called a dual sovereignty doctrine. Now, what that means is that the federal government, as far as case law is concerned, the courts see the states as a doctrine of itself, as far as a sovereign of itself, that is. So therefore, the state is one sovereign, and then the federal government is another sovereign. So what that means is that based upon the doctrine of dual sovereignties, the state can charge you with something that is the exact same offense, and the federal government can charge you with something that is the exact same offense. Now, even in law school, there's still law books that will tell you that the elements have to be different. There has to be at least one difference in the element in order for there not to be double jeopardy. Now, that's actually still true, but not in the context of if the state is charging you with something and the federal government is charging you with something. Now, if the state is trying to charge you with something where the elements are the same, then double jeopardy would apply, but not when it comes to the dual sovereignty doctrine. Now, you're going to look at this one case, and if you look at it, I'm going to do a split screen. You can see this case is Gamble v. United States. It's something that actually came from the 11th Circuit that went to the United States Supreme Court. It was decided in 2019, and it explains an awful lot about the dual sovereignty doctrine. And of course, there were a few dissents. One of the dissents was Justice Ginsburg. Now, as attorneys, you normally don't discuss dissents, but I am for the purposes of you out there so that you can kind of understand. What Justice Ginsburg stated was that basically the court's adherence, and I'll read it, to that misguided doctrine, instead of frittering away at Gamble's liberty upon a metaphysical subtlety, two sovereignties, grant the Lanza Rule, which is a case from 1922 that the court heavily relies upon, which is the one that basically cemented the dual sovereignty doctrine. Now, there were cases before then, but the U.S. v. Lanza in 1922 is one that basically stated that, yeah, you can have a crime in the state and crime in the feds, and it can be basically the same crime, and they could prosecute you. So what I was saying before is that, if you practice, criminal law, one thing you're always worried about is whether or not, if you had somebody plead guilty in federal court for a crime, if the state would then come and try to charge them as well. Now, what the prosecutors normally would tell us is that, we have, this agreement in place with the states and then other federal prosecutors that, once we actually charge them and we get a guilty, then they won't charge them. Now, here's the thing. As a lawyer, you're like, well, but we're not a part of the agreement because we didn't sign it. Are we third-party beneficiaries? Can we count on that agreement? The fact is that you don't have a guarantee. There isn't a guarantee. There's no way of getting one, but for the most part, they normally adhere to that. But in this Gamble case, basically what happened was that the state court judge sentenced this person to 10 years and then suspended all but one. So then the Fed said, that's not enough time, so we need to charge him. So they were able to charge them, and then he got some additional time. So when you look at whether that's fair or not, because we have the stare decisis, meaning that the previous courts had decided that this was good law, this court again decided in 2019 that this should still be good law. So now you have this dual sovereignty doctrine that's been around for a long time now, and that a lot of people, including some lawyers, don't know exist. I've had to explain this to many people that, yeah, you can actually be charged with the same crime in the state and the feds as long as it's criminal in both, meaning that there are statutes that actually make it so that you cannot do such. So overall, can they charge him in state court in New York for this, even though he got pardoned for it? Yes, because a presidential pardon does not count for state crimes. It counts for federal crimes. Should they? A lot of people will say no, and by far most defense counsels will say, yeah, please don't do that, because it makes our job much more difficult. And, you can see it as being unfair. It's going to be up to you to determine what you think of it. Now, that doesn't really mean very much because the courts have already decided that this is the way it's going to be. With any luck, you won't ever have to deal with anything like this. But as far as Steve Bannon is concerned, at this point, case law says that they can charge him even though he's been pardoned in federal court. Until next time, make sure you like this, share it, and subscribe to my YouTube channel. Thank you.